Very well, and this came up earlier in the forum tonight, maybe in another forum. This is again, two-part question. And one is, there's a forum when an opponent said there's a man guilty of stabbing his wife and throwing her out the window. She's now in a wheelchair. Evidently you stated it was not intentional. How can this be? Because she was stabbed 9 times. And then secondly, there's 2 prosecutors in Denton County that were found to have committed prosecutional, okay, you know what I'm saying, misconduct by intentionally withholding information that legally should have turned over to the defense attorney in a man who was accused of stabbing the wife going free. So Paul, explain that to us, and then each of you, Hank and Karen, I want y'all to explain how you would have handled it, okay?
The 2-part question is really dealing with the same case.
Okay, thanks.
And the bottom line is this. When you deal with family violence cases, you don't always have complainants that are with you. Sometimes they're with you and sometimes they're not with you. In this particular case, the defendant pled guilty and the trial was going forward. And at some point, there was some evidence, even though we have open file policy, that the prosecutors didn't disclose. They declared a mistrial and set it for another trial date. The defense attorney that was handling the case came to me and wanted probation and said, hey, listen, what we're going to do is we're going to go to the press. If you don't give us probation, you met in my office, and I don't deal idly with threats like that. I said, you know what? I'm going to be open above reproach. We're going to go ahead and have the court see if they believed that it was intentional violation of withholding some evidence or not. I do not believe, everybody's entitled to their opinion, I do not believe that those 2 prosecutors intentionally let that evidence out. It was an open file policy. It was out there. The bottom line is I would have fired him if I thought it was intentional.
Hank, how would you handle those situations?
I know both prosecutors are involved in this, and I agree with Mr. Johnson completely. I do not believe that it was an intentional act. And if it was an intentional act, I believe that he would have done exactly the same as I would do and would have fired the prosecutors.
Karen.
The judge who heard this case is in the room tonight. Judge Burgess, if you have any questions, please direct them at him. He found that it was an intentional violation by both of the district attorneys in not disclosing the information. And if Paul's open file policy works, then that information would have been disclosed. An open file policy is only as good as the information that you put in the file, and you don't put behind a desk drawer or in a different file in which you're not showing the defendant. In this particular instance, the state had the ability to remedy their problem before it went to a final hearing as to whether or not the violation had occurred, and they simply chose not to. It was ego over justice. When a judge found that the intentional violation had occurred, he found that the 2 prosecutors used the innate intellect of a 5th grader in making their decision, and that is a direct quote. He, at that point, banned those prosecutors from his courtroom, pending them getting training on what Brady is. And folks, these are felony-level prosecutors. These are not entry-level misdemeanor prosecutors. They intentionally violated Brady. They were banned from a district court, and your district attorney wrote a letter to the state bar stating that he was in defense of them and believed that the judge had done something wrong. There is no accountability in this district attorney's office, and it needs to change.